I watched Congress eliminate the $200 tax on suppressors and short-barreled rifles in a budget reconciliation bill that received almost no media attention. The tax that had existed for 91 years. The tax that was the constitutional foundation for the entire National Firearms Act regulatory structure. Gone with a single line item. Most people thought this was simply a tax cut. What they did not realize was that by removing the tax, Congress had destroyed the legal justification for every other restriction in the NFA system. The National Firearms Act derives its authority from Congress's constitutional power to levy taxes. The Supreme Court upheld the NFA in 1939, specifically because it was structured as a tax statute. When you remove the tax, you remove the constitutional foundation. Without that foundation, the entire regulatory structure collapses into unconstitutional prior restraint on a fundamental right. Lawsuits were filed within 48 hours. Multiple parties, multiple jurisdictions, all making the same argument. If there is no tax, there is no taxation power. If there is no taxation power, the registration requirements, approval process, and waiting periods are unconstitutional restrictions, lacking valid federal authority. The Department of Justice responded by arguing the NFA is a shall-issue licensing system. The government claimed that even without the tax, federal authority comes from the need to track inherently dangerous weapons. They argued the registration process serves governmental interests in public safety. That argument might have worked. Federal courts have upheld shall-issue licensing systems in other contexts. As long as criteria are objective and government must issue licenses to anyone meeting those criteria, courts generally defer to the regulatory scheme. But then the plaintiffs filed their supplemental brief, and that brief contained something the Department of Justice was not prepared to defend. Actual ATF denial letters showing the agency does not operate the NFA as shall issue. It operates it as discretionary approval, where applications are routinely denied based on subjective criteria having nothing to do with statutory disqualifications. The evidence was devastating. One applicant was denied a suppressor because his stated reason was to exercise my constitutional rights. The ATF examiner noted this demonstrated an adversarial attitude toward federal regulation. An approval would not be in the public interest. The applicant had no criminal record, no disqualifying mental health adjudications, no statutory prohibition. He was denied purely because the examiner disliked his motivation. Another applicant was denied a short-barreled rifle because photographs showed tactical features. The denial stated that while he met all statutory criteria, the configuration suggested use beyond sporting or collection, therefore approval was declined. There is no statutory requirement that NFA items be used for sporting purposes. That standard was invented by the examiner. A third was denied for filing multiple applications in a short period. The denial cited volume suggesting commercial intent or trafficking concerns, though the applicant was not a dealer and had no illegal activity history. The examiner decided wanting multiple NFA items was inherently suspicious. The plaintiffs submitted 47 documented denials based on criteria appearing nowhere in the NFA statutory text. Subjective intent assessments, speculation about future use, examiner concerns about applicant attitudes, personal opinions about legitimate ownership reasons. This is discretionary system definition, and discretionary systems cannot be applied to constitutional rights. The Supreme Court has been clear on this for over 60 years. You cannot give officials unbounded discretion to decide who exercises a fundamental right based on personal judgment about whether that exercise is appropriate. That is exactly what the ATF has been doing, and now that evidence is in the federal court record. The Department of Justice tried arguing these were aberrations, mistakes by individual examiners not reflecting official policy, but plaintiffs countered with internal ATF training materials explicitly instructing examiners to consider applicant intent, firearm configuration, and public safety concerns when evaluating applications, even for individuals meeting all statutory criteria. The training materials state examiners should use professional judgment to determine whether approval would be consistent with public interest. That phrase appears nowhere in the National Firearms Act. It is administrative invention, converting shall issue into may issue. And may issue systems for constitutional rights are unconstitutional. The Supreme Court said so explicitly in Bruin when it struck down New York's concealed carry licensing. New York required demonstrating proper cause, and officials had discretion to deny even when statutory criteria were met. The court held that discretionary approval for Second Amendment rights violates the Constitution. The NFA system is actually operated as functionally identical to the New York system Bruin invalidated. Applicants must apply for permission. Officials review and have discretion to deny based on subjective factors. The only difference is carry permits versus ownership of specific items. But the constitutional analysis is identical. Discretionary prior restraint on fundamental rights is not permitted. The federal judge handling consolidated cases ordered the ATF to produce all denial letters from the past 5 years with internal file notes explaining each denial basis. The government objected, claiming this would compromise law enforcement methods and reveal sensitive investigative techniques. The judge rejected that argument and ordered production within 60 days. When those documents are produced, the scope becomes visible. If the pattern in the initial 47 cases is representative, thousands of applications have been denied based on criteria having no statutory foundation. Thousands of individuals prevented from exercising Second Amendment rights based on examiner discretion rather than legal prohibition. That is constitutional crisis, not abstract, concrete. A federal agency has been operating prior restraint on constitutional rights without legal authority. The tax elimination timing makes this crisis impossible to resolve through administrative reform. If the tax still existed, the government could argue that while administration may have been imperfect, underlying taxation authority provides constitutional basis for requiring some application and review. But the tax no longer exists. Without the tax, there is no constitutional basis for requiring federal permission before exercising the right to possess these items. The plaintiffs are asking the court to declare that without the tax, registration and approval requirements are unconstitutional prior restraints that must be enjoined. If they win, suppressors, short-barreled rifles, short-barreled shotguns, and potentially other NFA items would be treated like any other firearms accessory, available for purchase without federal approval, registration, or waiting periods. State laws would still apply. States prohibiting these items could continue under state authority, but federal restrictions would evaporate. In the 37 states currently allowing NFA items with federal approval, they would become immediately accessible to anyone not otherwise prohibited from firearm ownership. Market response has already begun. Suppressor manufacturers increased production capacity by 35% over 6 months, anticipating a favorable ruling. Retailers are stockpiling inventory. Industry analysts project that if federal restrictions are removed, suppressor sales could increase from approximately 500,000 units yearly to over 5 million within 18 months. The same projections apply to short-barreled rifles. Current NFA registrations total approximately 800,000 nationwide. If federal approval requirement disappears, industry estimates suggest that could reach 15 million within 3 years, because the only barrier preventing most AR-15 owners from configuring shorter barrels is federal registration and approval process. But the larger implication is not economic, it is structural. The National Firearms Act has been the foundation of federal firearms regulation for 91 years. It established that certain weapons are so dangerous that federal oversight is necessary, even if outright prohibition is not constitutional. It created the registration, taxation, and approval template applied to machine guns, destructive devices, and other weapons. If the court rules this system cannot survive without the tax, and the tax elimination was valid, the entire framework collapses. Not just for suppressors and short-barreled rifles, for everything the NFA covers. The same constitutional analysis applies. If requiring federal approval before exercising Second Amendment rights is unconstitutional prior restraint, it is unconstitutional for all NFA items. The government knows this, which is why they fight so hard to characterize the system as shall issue rather than discretionary. If they lose that battle, they lose the entire regulatory structure, and the evidence of discretionary denials makes that characterization impossible to sustain. I have watched federal regulatory systems unravel before. The unraveling does not happen through dramatic collapse. It happens through court decisions that progressively narrow permissible regulation until nothing remains. That process has started. The tax elimination removed constitutional foundation. The discretionary denials destroyed the shall issue characterization. Bruin precedent established that discretionary systems for constitutional rights are impermissible. The pieces are in place. The only question is whether the court will follow the logic to its conclusion. Multiple federal judges in different circuits are reviewing similar cases with similar evidence. Some will rule for the government, some for plaintiffs. Circuit splits will emerge. The Supreme Court will eventually be forced to resolve the conflict. And when it does, the 6-justice majority that decided Bruin remains intact. That majority has shown no inclination to defer to federal regulatory authority when constitutional rights are at stake. They have consistently applied historical tradition analysis strictly. They have consistently rejected interest balancing and public safety justifications for restrictions lacking historical foundation. They have consistently ruled that common use equals constitutional protection. Suppressors are in common use. Over 4 million are registered. Short-barreled rifles are in common use. Over 800,000 are registered. Historical tradition does not support requiring federal permission to own firearm accessories or to configure firearms with different barrel lengths. The tax that provided constitutional cover no longer exists. The conclusion is inevitable. The NFA regulatory structure for these items cannot survive constitutional scrutiny under current precedent without the tax, And Congress eliminated the tax without understanding they were eliminating constitutional foundation. This was not deliberate strategy to dismantle the NFA. This was a budget reconciliation provision intended to provide minor relief to gun owners complaining about excessive fees. The staffers who drafted it had no idea they were pulling the keystone from an arch. But keystones do not care about intent. When removed, the arch falls. Federal courts are now deciding whether to acknowledge that the arch has fallen or to pretend it is still standing through administrative characterizations that the evidence does not support. Based on the initial rulings and the quality of the evidence being presented, multiple judges are preparing to acknowledge reality. The National Firearms Act, as it has existed for 91 years, is in the process of being fundamentally dismantled, not through legislation, not through executive action, through the intersection of a tax elimination and constitutional precedent that government lawyers fail to anticipate. I am watching the foundation crumble. The structure is still standing, but it is standing on nothing.